Are you wondering how to seamlessly transfer your bank accounts into your newly established living trust, avoiding the complexities of probate and potential complications for your heirs? Well, today we're delving into the crucial steps to make this happen efficiently and effectively. Hello, I'm Ted Gudorf, a board-certified estate planning attorney in Dayton, Ohio, and the owner of Gudorf Law Group. Before we dive into the nitty-gritty of transferring your accounts, let's start by exploring the fundamental concept of a trust. While I hope that if you're concerned about transferring accounts into a trust, you've already established one. It's always beneficial to revisit the basics to ensure that we're all on the same page. A living trust, in essence, is a powerful legal instrument that acts as a metaphorical bucket into which you place your assets. As long as you're alive and of sound mind, you maintain full control over this bucket. You hold the proverbial handle, allowing you to manage the assets within the trust with complete autonomy. This means you can add or remove assets, transfer them to other individuals, use them as collateral for loans, sell them, or essentially do anything you normally do with assets you own outright in your own name. The key distinction here is that while you maintain control, the trust itself becomes the legal owner of these assets. This subtle yet significant difference brings about numerous benefits, chief among them being the simplification of asset management in case of your incapacity or death. Let's paint a scenario to illustrate this point. Imagine you, unfortunately, suffer from a debilitating condition like dementia or experience a severe stroke, rendering you unable to manage your own affairs. In such a situation, the person you've wisely designated as your successor trustee can seamlessly take control of the trust bucket. They'll manage the assets within for your benefit as long as you're alive, without any probate court involvement, ensuring your financial matters continue to run smoothly despite your incapacity. Now, contrast this with the alternative. If you don't have a trust in place, your family might find themselves navigating the complex and often traumatic process of going to probate court for a guardianship or a conservatorship. They need to have you declared legally incompetent, a procedure that can be not only lengthy, but also emotionally draining and financially burdensome for your loved ones. By establishing a living trust, you're proactively avoiding this potential hardship for your family. But the benefits of a living trust extend beyond incapacity planning. Let's consider what happens when you pass away. Without a trust, even if you have a will or no formal plan at all, your estate will inevitably go through the probate process. This is a court-supervised procedure with the court in control. It is typically referred as an executor, an administrator, or personal representative, depending upon the jurisdiction. That person gets appointed to be in charge of your estate under the control of the probate court. This court-appointed individual bears the responsibility of wrapping up your affairs, which includes tasks such as paying off debts, filing final tax returns, and distributing your assets according to your will or state law if you die intestate. However, before they can undertake these duties, they must go through the formal probate process, be officially appointed by the probate court, possibly get a bond, and be granted the legal authority to manage your assets. This can be time-consuming, potentially costly, and may delay the distribution of your assets to your beneficiaries by more than a year. With a living trust, we circumvent this court process entirely. The successor trustee you've chosen simply takes control of the trust bucket after your passing. They then proceed to distribute the assets within the trust according to the explicit instructions you've left behind. These instructions, carefully detailed in your trust document, might specify how you want your assets divided among family members, or perhaps designate specific assets to go to your alma mater, a cherished charity, or your local place of worship. Your successor trustee follows these instructions to the letter, distributing your assets efficiently and privately without the need for court intervention. This is not only going to save time and potentially reduce costs, but it will also maintain your family's privacy, as probate proceedings are typically matters of public record. Another significant advantage of a living trust is its ability to avoid multiple probate proceedings if you own property in different states. For instance, if you have a vacation home in Florida, but reside in Ohio, a living trust can save your heirs from having to go through probate in both states, streamlining the process considerably. Well, now that we've established what a trust is and its myriad benefits, let's address why including your bank accounts in your trust is such a crucial step in your estate planning journey. Many individuals, particularly those who are married, might question the necessity of this step. They often say, well, I have a joint account with my spouse, so if something happens to me, there won't be any issues. While this may be true in some scenarios, it doesn't account for all possibilities. Consider a situation where both you and your spouse are involved in a serious accident, leaving you both temporarily incapacitated. If your bank accounts are held within a trust, your designated trustee can step in to immediately manage your financial affairs. They can ensure that your bills are paid, necessary transactions are made, and your financial life continues smoothly during your recovery period. Once you're back on your feet, you can seamlessly resume your role as trustee, taking back control of your finances without missing a beat. However, without the protection of a trust, your family might find themselves in the unenviable position of having to file for a guardianship or conservatorship through probate court. This is a legal proceeding to appoint someone to manage your affairs during your incapacity, and it can be time-consuming, expensive, and potentially stressful for your loved ones during an already difficult time. The bottom line is it puts the probate court in charge. Now, I often hear from some of my elderly clients a suggestion that seems on the surface to be a simple solution. Can't I just add my adult child to my bank account? Then they can take care of things if I'm unable to. Well, this approach can indeed work in terms of allowing your child to manage the account if you're incapacitated. It's akin to seeing only the tip of the iceberg while ignoring the potential hazards lurking beneath the surface. Let's explore some of the hidden risks associated with simply adding a child as a co-owner on your bank accounts. Number one, exposure to creditors. By adding your child as a co-owner, you're potentially exposing your assets to their creditors. If your child faces financial difficulties, perhaps they run up against credit card debt or face a lawsuit, your joint account could be at risk. Creditors could potentially access the funds in the account to satisfy your child's debts, even though the money originally belonged to you. Number two, unintended gifting issues. When you pass away, a jointly held account automatically becomes the property of the surviving owner. In this case, your child. Let's say you have two children and your intention was for the funds in the account to be split equally between them. If the account holds $100,000 when you die, it becomes your co-owner child's property. If they then give $50,000 out of the goodness of their heart to their sibling as you intended, this is considered a gift for tax purposes. Your child would be required to file a gift tax return with the IRS. Well, they likely won't owe gift tax thanks to the lifetime gift tax exemption. This transaction would use up a portion of their lifetime exemption. This could have unintended consequences for their own estate planning down the line. Number three, potential family conflicts. Adding one child to your account but not others can create perceptions of favoritism or unfairness, potentially leading to family discord after your passing. Number four, a loss of control. While you might trust your child implicitly, adding them as a co-owner gives them equal rights to the funds in the account. They could theoretically withdraw funds for their own use without your permission. Number five, Medicaid eligibility. If you need to apply for Medicaid to cover long-term care costs, jointly held accounts are typically considered available assets, potentially affecting your eligibility for Medicaid. Given these potential pitfalls, it becomes clear that setting up a living trust and transferring your bank accounts into it is a far more secure and flexible option. It allows you to maintain control, protect your assets, and ensure your wishes are carried out exactly as you intend, without exposing yourself or your heirs to unnecessary risks or complications. Now that we've established the importance of transferring your bank accounts into your living trust, let's walk through the process step by step. It's important to note that while the general principles remain the same, every financial institution has its own specific rules and procedures for this process. What I'm about to describe is a general approach that works in most cases, but your particular situation may vary slightly. Step 1. Review your trust agreement. Before you begin the process of transferring accounts, take some time to review your trust agreement thoroughly. If it's been a while since you set up your trust, circumstances may have changed. Ensure that the individuals you've named as successor trustees are still the people you want in those roles. Review how you've specified assets to be distributed among your beneficiaries and confirm that this still aligns with your current wishes. If you find that changes are needed, consult with your estate planning attorney to make the necessary amendments before proceeding with account transfers. Now, step 2, gather the necessary information. To make the transfer process as smooth as possible, gather all the necessary information beforehand. This typically is going to include your account details. Have your account numbers and the exact names on the accounts readily available, preferably through copying a statement. Trust documentation. Most states have created the document known variously as either a certificate of trust, a certification of trust, or an affidavit of trust. This is essentially a sworn statement that confirms the existence and validity of your trust. It typically includes information such as the date the trust was created, your name as the grantor, the person who created the trust, and a statement that the trust remains valid under state law. This certificate or certification is usually sufficient for most financial institutions to proceed with the transfer. However, some banks may request a complete copy of your trust document. While in many states they can't legally require this, a certificate of trust should be sufficient. You'll need to decide whether it's worth arguing this point or if it's simply easier to provide the full trust document. If you do decide to provide a full copy of your trust, be aware that there's always a small risk of unintended disclosure. I've had instances where a bank has forwarded a client's trust document to a real estate attorney handling a closing without the client's specific authorization. While rare, it's something to keep in mind when deciding how much information to provide a bank. Step 3. Contact your bank. Before visiting your bank in person, it's wise to make an initial contact either by phone or through their website. Inform them that you've set up a living trust and need to transfer your accounts into it. Ask about their specific requirements and whether they have particular forms for this process. Many banks have a document called a change of ownership form. This is what you'll use to change the owner of the account from your personal name to your trust name. The formal name of your trust should be on your certification of trust. In your trust document, it typically follows a format like the John Doe Living Trust dated January 1, 2024. Step 4, complete the necessary paperwork. While it's often possible to download forms and complete them at home, I generally recommend visiting your local branch in person if possible. A customer service representative can guide you through the process, ensuring all the forms are filled out correctly. If you do go to the bank, you'll likely need to sign the form both as the current owner of the account and as the trustee of your trust. The bank representative should be able to walk you through this process. If you're handling this remotely, carefully follow the bank's instructions for completing and submitting the forms. Pay very close attention to any requirements for notarization or additional documentation. Step 5. Once you've completed all the necessary forms, submit them along with your certification of trust or full trust document if required to the bank. If you're handling this in person, the bank can often process the change immediately. If you're submitting documents by mail or electronically, make sure to follow up to confirm receipt and processing. It's crucial to verify that the transfer has actually been completed. Step 6, verify the transfer. After submitting your paperwork, it's essential to confirm that the transfer has been successfully completed. There are two main ways to do this. First, simply check your next account statement. Look for an indication that the account is now held in your trust name. This might appear as your name followed by trustee, or the full name of your trust. Request a confirmation letter. Ask the bank to provide a letter on their letterhead confirming that the account has been transferred into your trust. Just remember, don't skip this verification step. If the transfer hasn't been properly completed, your account won't enjoy the benefits of being held in your trust, potentially leading to probate or other issues down the line. So what are some of the common mistakes to avoid? As we wrap up, let's review some common mistakes people make in this process. Number one, forgetting to update beneficiary designations. While checking and savings accounts typically don't have beneficiary designations, other financial assets often do. These might include retirement accounts, life insurance policies, annuities, or certain investment accounts. If you want these assets to be controlled by your trust, after your death, you need to update the beneficiary designation to name your trust as the beneficiary. Before doing so on a retirement account, make sure you consult with your estate planning attorney. Let me give you an example. If you have a life insurance policy and want the death benefit to be distributed according to the terms of your trust, you would name the trust as the beneficiary of the life insurance policy. This ensures that when you pass away, the insurance company will pay the death benefit directly to your trust. Your trustee can then distribute the funds according to your wishes, as outlined in the trust document. Oftentimes, we're going to have sub-trusts in our accounts that are going to receive the life insurance proceeds so that those proceeds are protected during the beneficiary's lifetime. This is particularly important if you have minor children. You don't want a large life insurance payout going directly to a minor child. Instead, you want the trust to control and distribute those funds appropriately. Number two, failing to confirm the transfer. As mentioned earlier, always verify that the account has actually been transferred into your trust. Don't assume it's been done just because you submitted the paperwork. Number three, transferring the wrong accounts. Be strategic about which accounts you transfer. While most personal accounts should go into your trust, there may be exceptions. For example, some retirement accounts can't be owned by a trust during your lifetime due to tax simplification. Number four, not informing other account holders. If you have joint accounts, make sure all account holders are aware of and agree to the transfer into the trust. Number five, forgetting to transfer new accounts. Remember that any new accounts you open after creating your trust should also be titled in the trust name. Ensuring your estate is managed smoothly and according to your wishes is a complex but crucial task. If you're feeling overwhelmed or unsure about any aspect of this process, I invite you to get in touch with us at Gudorf Law Group. We specialize in making estate planning as straightforward and secure as possible. Visit our website or use the link in the description of this video to book a consultation. Remember, the time and effort you invest in planning today can bring immeasurable peace of mind for tomorrow. If you're interested in learning more about estate planning, I encourage you to subscribe to our YouTube channel. We regularly post valuable information on various aspects of estate planning that you won't want to miss. Well, thank you for watching today. I'll see you in the next video where we'll continue to demystify the world of estate planning and help you secure your legacy for the benefit of your family.